Okay, we are making it through the semester. It is week 15, and this will be the last video lecture before your final exam next week. We're going to do chapter 18, which is legal briefs. So let's just recap. Up through chapter 17, we've learned about the jurisdiction of the courts. We've learned about knowing how the courts are organized between the state and the federal systems. We've learned how to do legal research with primary and secondary sources. We've learned how to use Westlaw. We've learned, or refreshed, our skills on writing in general with parts of speech and sentence structure. We have learned how to write legal correspondence, which again is a really big part of what you do in a legal office. And we've learned how to write a legal memorandum. Okay? All of those things are kind of outside the system, the court system itself. We might have a little bit of overlap with letters, maybe going to opposing counsel about something that's going on in court, or going to a court reporter where you're scheduling a deposition. But normally those are going to be out, so you're not going to write a letter to the judge. And when it comes to the legal memorandum, that's within the confines of a law office. Legal briefs, on the other hand, are strictly in the court system. You're going to use some of the research that you did in the legal memorandum in the legal brief, but it is something that you prepare wholly for a judge's eyes. Okay? Let's review real quickly how a case goes through the system, first of all, before we actually talk about what a legal brief is. Remember, before a case is filed, we try to do legal correspondence, maybe a demand letter, to try and get the case to settle, to try and not have to file a lawsuit, because lawsuits take time and money. And if you can settle the case, you should settle the case. But if that doesn't work, then you go to the trial court. And again, depending on which jurisdiction you're in, federal or state, that will determine which trial court you go to. But the first step in the legal process is a trial, where you can have a jury, or you can say, nah, I'm just going to let the judge decide. It's really up to you as the litigant as to whether you want to waive a jury trial. You go through witnesses and exhibits and arguments to the jury or to the court. It can take 2 days for a trial. It can take 2 months for a trial, depending on how many issues you have. Ultimately, at the end of the trial, there is a decision. And again, if you have a jury, it'll be the jury's decision. If you have just the judge trying the case, the judge will render an opinion or render a decision. If you don't like how that decision comes out, automatically, as a matter of right, you have the ability to take your case to the next level, which is the first level of the appellate process. And in the appellate process, you will go either to the Circuit Court of Appeals. You'll either go to the Circuit Court of Appeals if it's in the federal court system, or you will go to the appellate system within your state. Right? In Ohio, those are called districts. Each appellate court has a district within Ohio. So when we're talking about the appellate system, we are not going to retry the case. We are not going to have witnesses. We are not going to have exhibits. We are not going to present testimony or make arguments, at least not to a jury or the judge in the same way we do at the trial court. Instead, what we do is we file what's called a brief, which, by the way, is anything but brief. But you're going to file a brief outlining what you think went wrong at the trial court. Maybe the trial court said, nah, I'm not going to let that witness testify. Or maybe the trial court said, no, I'm not going to grant your motion to dismiss. Or maybe the trial court said, you know, you can present these photographs to the jury, but not these ones. Or maybe the trial court says, you know, I'm going to decide what I'm going to instruct the jury about as far as the law is concerned and what law they should be applying to the facts in this case. And maybe you don't like that. Maybe you think the judge left out a particular jury instruction or gave the wrong jury instruction. Each one of those things that I just talked about would constitute an issue that you would then set forth in a written document called a legal brief or an appellate brief, and you would file it with the Court of Appeals. The Court of Appeals is going to look over everything that happened at the trial court level. They're going to look at the transcript of the testimony. Everything that happens in a trial is taken down by a court reporter. I don't know if you've ever gone into a courtroom before, if you've watched court TV. There's always an individual sitting at one side of the judge, and then there's a spot for the witness who's going to testify on the other side of the judge. The person that sits there the whole time is a court reporter. They are tasked with taking every syllable of every word that is uttered during the course of that trial. And then what happens to that? Well, if someone appeals the decision up to the Court of Appeals, that transcript gets transcribed and then follows the case up to the Court of Appeals. So the judges can read exactly what happened. So you can't say, that meanie judge said wah, 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 wah. And they're going to look at the transcript and say, I don't see any wah, 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 wah. Right? They're able to see for themselves exactly what happened without any kind of embellishment from either side. Okay? So the transcript goes up, and if you, typically if you lose, you're the only one that will appeal. There are cases where people who win think, I didn't win big enough, so they file a notice of appeal. But let's just stick with the obvious. If I lose at the trial court, I've got to tell the Court of Appeals exactly why I think the judge at the trial court level made a mistake. Again, did they not admit some piece of evidence, or did they admit a piece of evidence I thought shouldn't have come before the jury? Did they give the wrong jury instructions? These are your typical issues that you are going to raise on appeal. You have to outline them very plainly. The issue presented. Why are you here? That's what the Court of Appeals wants to know. What are you doing here? Okay? So whoever files the appeal files their brief, their appellate brief, outlining what the issues are, and then giving all the law, saying why they think they were wronged by the trial court. And then the other party will file a response brief. And then the appealing party, or the appellant, gets one more bite of the apple with a reply brief. Okay? Whoever files the appeal is called the appellant, and whoever responds to the appellate brief, the party that won at the trial court level, is called the appellee. Appellant is A-P-P-E-L-L-A-N-T. Appellee is A-P-P-E-L-L-E-E. Okay? So there's a lot of paper going on here. There's a lot of writing going on here. Right? Then what? Well, the Court of Appeals will set a hearing date. There are no witnesses. Typically, there's no client there. There's no extra paper. You don't present new stuff. Each attorney for the appellant and for the appellee stands before a panel of judges, anywhere from 3 to 7 judges, depending on which Court of Appeals you're in. and you argue your case. What does that mean? If I'm the appellant, I'm going to stand before the Court of Appeals first. I'm going to say, may it please the court, my name is Diane Hetson, and I'm here on behalf of the Smith family, and I am the appellant. We believe that the trial court below erred as follows. Issue 1, Issue 2, Issue 3, and by the time I get to Issue 2, I'm probably going to get a question from one of the judges. And I have to stop what I'm saying and I have to respectfully answer that judge. And then, once I'm done answering, I'll try to get back into my prepared argument. By the way, you only have a set period of time. Depending on the court, it can be anywhere from 10 to 15 minutes. Okay, that's it. That's all you got. Now, when you get to a higher level, the Supreme Court, or say the Supreme Court of your state, the court will, depending on what the issue is, grant you more time. But at that first level, keep on moving. Okay? So one judge asks me a question, I answer it respectfully, and then I go back into my argument. But as soon as I say 2 words, another judge asks me questions. And I have to answer those questions. And I might not be able to do my whole argument. I might be answering questions all over the place. At which time I will say, I see my time has expired. May I briefly conclude? And then I'm going to say, in conclusion, appellant respectfully asks this court to reverse the decision of the trial court below. Thank you very much. Sit down. Then the lawyer for the appellee gets up, and the same thing happens. You know, may it please the court, my name is, I'm here on behalf of appellee. Let me tell you why appellant's argument is wrong. Question, 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 question. I see my time is concluded. May I briefly conclude? Now, most of the time it happens that way. Sometimes the judges have either made up their mind before you even started arguing, or they didn't read your brief and they have no questions for you, or they're just not interested. And so you'll go through your whole argument without a question. Okay? I've had it both ways, right? And I did appellate work for a long time. And it really just kind of depends on what the case is about. And it really kind of depends on how innovative your arguments are, or if you're trying to stretch too far, they may challenge you. Sometimes you get friendly questions, sometimes you get challenging questions. Okay? Then, typically anywhere from 3 to 6 months later, you will get the opinion of the court, where all of the judges, or a majority of the judges, will agree to one written opinion that one of the judges will write. Okay? Those are the opinions that you're reading. When you go on Westlaw, you'll see Judge so-and-so wrote the opinion at the very end. It'll tell you the names of the other judges that agreed or concurred or dissented with the opinion. Okay? That's what you've been reading, are appellate decisions that are based on appellate briefs that are then argued before the judges. Okay? Are we putting all these pieces together? So when you're on Westlaw, 9 times out of 10, you are reading an appellate court decision. So it's kind of important to know what that's about. Now, what if I lose at that first tier of the appellate? Remember, I don't have a second appeal as of right. So if I want to go from the Circuit Court of Appeals to the U.S. Supreme Court, I have to file for what's called a writ of certiorari, or a writ of cert. And a writ means just a petition for the court to allow you to file another appellate brief. Okay? In Ohio, it's the same thing. If I lose at the district appellate court level and I wish to go to the Ohio Supreme Court, I have to file for a writ of cert. Most of those get denied. Most of them. Think about it. You've got all these appellate courts all over the country, all over the state. They can handle a bunch more cases. You only got one U.S. Supreme Court. The state of Ohio only has one Supreme Court. They're a bit more picky. Unless there's a compelling reason for them to take the case, they won't. And if they choose not to take the case, as we learned in our citations section this semester, the decision of the lower appellate court stands. That becomes the law for the state. That becomes the law for the United States. Okay? So this is kind of an important process to know about. So we're going to take a few minutes just to learn about what goes into an appellate brief. I'm not going to have you write an appellate brief. These are really extensive documents to write. Typically, you will take a case from beginning to end with an appellate brief, and you have all that research, and you know the case inside and out because you've been to trial. You know every nook and cranny of this case, and so you're able to argue it in the Court of Appeals. The problem is appellate briefs are anything but brief, and there is a format that you have to follow. So why am I having you learn this if you're not going to write an appellate brief? Well, because you might not write an appellate brief, but you might have to proof the cites. You're going to have to see whether the table of authorities is correct. You're going to have to make sure that the pages or the sections are where they need to be. You may have to be asked to be the proofreader. So let's learn about it. Okay? So every appellate brief starts with a cover page that lays out what is in what is the title of the case, what's the case number, and who the attorneys are. Okay? If you are going to write an appellate brief, you need to make sure that you are putting the appellate case number on it and not the trial court case number on it. When you appeal to the Court of Appeals, it goes to a whole new clerk's office. They have a whole different filing system, and it will have an appellate court number. Usually has the letters AP in it. Okay? So after your cover sheet, you are going to have your table of contents, your table of authorities, your jurisdictional statement, the question presented, which was the issues, your statement of facts, your statement of the case, the argument, the conclusion, and then certificate of service and signature. That's a lot. That's a lot of stuff. So what I'm going to focus on is the table of authorities, because we've been spending this entire semester learning about different kinds of authorities. Okay? Every case, every statute, every authority that is relied upon in the argument portion of your appellate brief must be cited in your table of authorities. Okay, what a big deal is that? I'm just going to copy and paste them. How tough is that? Well, you kind of have to put them in the right order. First of all, we put federal cases first, federal statutes second, state cases next, state statutes second, and then any kind of secondary authorities like treatises or attorney general opinions. Those go at the very end. Then within each section, each authority needs to be put in alphabetical order. Okay? How do we do that? Well, it's the first word in the case will be in alphabetical order. And if we're talking about statutes, it is in numerical chronological order from smallest to largest. Okay? That's not the end of it. Then you have to put every page within the brief that authority appears on. So if I cite the case of Smith versus Jones, and it appears on page 4, 7, 12, 13, and 14 of the argument portion of my appellate brief, that must appear in the table of authorities. Why is that? Well, because if I am checking to see what you are relying upon, it's a quick way for me to pull the case and then read the argument itself. It's a nice cross-reference point. Okay? It's a very important part procedurally, technically, of doing an appellate brief. And that's why I'm saying you may be asked to double check that if you work in a law office. Now, there are programs out there that will do that work for you. If you work in a smaller law firm, you probably don't have that program. If you work in a larger law firm or corporation that does a lot of appellate work, you're going to have that. But those aren't infallible. You might add a little bit to a brief as an attorney, or take away a paragraph if you reread it and say, it doesn't work so well, and not rerun your table of contents. your table of authorities. So now your pages are off, which makes a problem. Okay? So it's a big deal to know what the table of authorities are. Okay? Questions presented, that's your issues. What are we here for? That's what the court's going to look at. What's your beef? What are you upset about? What did the trial court do? That goes under questions presented. Okay? Then we have statement of the case. Statement of the case is procedurally what happened in this case. Once the complaint was filed, what happened in the court? Now that's different from statement of facts. Statement of facts is everything that happened before the complaint was filed. Okay? Two different things, two separate parts of an appellate brief. Your argument is your meat and potatoes of your brief. Your argument is where you are going to take each issue, each question presented, it's going to be a heading, and you're going to IRAC those cases that you find persuasive to show the appellate court that the trial court goofed. Some of those cases, you're going to reach all the way back to your first memorandum that you wrote. And you're going to pull that case and you're going to plunk it into your appellate brief. You're going to massage it. You're going to, make it a bit more persuasive, but usually a lot of your initial research from your initial memorandum of law ends up in an appellate brief if you end up losing in the trial court. Or even if you don't, if it goes to the Court of Appeals and you're the appellee, not the appellant, you might be pulling that language from your memorandum. You're still going to have to do more research. You're still going to have to key cite. You're going to have to make sure it's good law. You're going to have to make sure that there aren't any bad cases out there and that you address them. But that's the meat and potatoes of your brief. That's what you go up in front of the panel of judges to argue. Okay? After your argument, you'll do a whole separate section that's called conclusion. There will be another whole section where you sign and date it, and then a certificate of service for showing the court, hey, I got a copy of this to opposing counsel. Okay? There are some 10 pointers for effective brief writing. These are really good. Okay? First is know the rules of the court that you're going to. Each appellate court will have their own local rules. Usually they're about the same, but some of them have shorter time periods or longer time periods for getting briefs in, different notices, different time periods for making your arguments. You better know those. Where do you find them? Online. Just, if I'm in the 11th District Court of Appeals, I'm going to go online, Rules of Court, 11th District Court of Appeals, boom, they'll come up. If I don't have any Wi-Fi, I'm going to call the court. Hey, court, can you send me a copy? Absolutely. That's not a problem. Okay? Do more than summarize cases. That's what IRAC's for. Don't just summarize them. Don't just say this, 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 and this. Draw a conclusion and make it strong when you're doing your brief. Okay? Right from the client's perspective. This is part of being persuasive. That's what's different from a memorandum. Remember when we talked about a memorandum, it was objective. We didn't want to put the client's perspective in. In this document, we're trying to be persuasive. Use some strong language and do it from your client's perspective. Okay? Avoid a rote or routine method of writing. I'm just going to tell you, eye-racking could feel like it is a routine. It's the most persuasive way to do things. So stick to IRAC. Avoid string citing, which is instead of me IRACing every case, I just IRAC one case and then I put a bunch of other case citations afterwards. Don't do that. The court's going to be like, what are you, a court? We're the only ones who do that. Every case that you're citing, make sure you've IRAC'd it. Avoid sarcasm, humor, and irony. Okay, you can do it from your client's perspective, but don't get smart with the court. They don't really like that too much. Avoid overuse of quotations. Depending on what you're doing, you may need to include quotations from depositions or quotations from trial testimony. You have to put them in. And so is that overuse? I don't think so. I think what this is talking about more is don't just quote from cases that you're relying upon. Summarize them. If you're going to quote, just put in a small quotation. Okay? Keep the focus on your argument. Always come back to, hey court, this is what I want you to do. You need to either affirm or overturn, depending on your position, the decision of the trial court. Okay? Do not fudge. Your book says don't distort. Don't fudge. Don't stretch. Don't BS the court. You will lose credibility. It's just like life, right? If I'm known as a BSer, you're going to believe me? No. So don't BS the court. It will come back to bite your client. That's no good. Okay? And this says use prominent placement to emphasize the strongest arguments. Start with your strongest argument and then work backwards. Okay? Okay. That's it for this chapter. There is an exercise for you to complete and a discussion. If you're interested, you can go on the U.S. Supreme Court website. You can read legal briefs, if you can't fall asleep at night. Go on there, read them. And it'll give you a real good sense of how good appellate briefs are written. If you've gotten to the U.S. Supreme Court, first of all, the clerk's office isn't going to let you file it unless it's good, or if it's the correct format. Read them. Take a minute. If there's one of the, we just had a string of really kind of earth-shattering U.S. Supreme Court decisions come down. Wouldn't it be kind of cool to see the arguments on either side and then see what the court, why the court decided it the way it did, instead of just listening to talking heads on TV? Be a little smarter than the average bear. Go read it. And again, do it with the intent of understanding how appellate briefs and the whole system work. You'll be smarter when you're done with it. Okay? I hope you learned something this semester. I hope it was useful to you. Again, if you have any questions with the problems with the exercises, please reach out to me. More than happy to walk you through them. Okay? And I wish you good luck with your final project, and that's the next module on the Blackboard program. Okay? Thanks again.